IIT School of Architecture and Planning. I welcome you all to the workshop on IPR awareness, generation, promotion, and augmentation in the IPR filing. For the three domains, we have architecture, planning and design, applied arts, fine arts, and visual arts, and rehabilitation science. Now, I call Dr. Pradeep Joshi sir to welcome the dignitaries and the guests to the event.
Good afternoon to all. I would like to welcome all for this domain-wise workshop on the IPR awareness, generation, promotion, and augmentation in IPR filings, which is being conducted by MIT IPR Cell, IIC, and Faculty of Studies for Architecture, Planning and Design, Applied Art, Fine Arts, Performing Arts, Visual Arts, and Rehab Sciences today. As I see that we have got good number of faculty members and research scholars here, offline as well as the online. And as we are aware that this is one of the very important topic and very much relevant, if I say that for our creative domains, it's very important. And rather, I must say that it is much needed, I must say. And if I talk about our faculty, we started filing the patents only last year. And I think so that the guidance from the MIT IPR cell has been a great help. So this is one of the good initiative which has been taken by the university to do these workshops at the domain level and the group of the faculty level to have a direct interaction with the faculties and the research scholars, because the people who are working or they have just started working upon that, so they will get an idea that what is the process, how should they go ahead about it, and what is its relevance. And MIT being a pioneer in terms of filing the patents and getting the patent registered, I think that this is a very great initiative. Today, I would like to welcome Dr. Chandeep Tandar, Additional Pro VC and the Dean Faculty of the Bioscience and Technology, for being here with us here. And we also have with us Dr. Smita Sahu, Director, MIT IPR Cell, and Professor, Indian Patent Attorney and a Certified IP Trainer from the Japan Patent Office. We also have with us Dr. S.K. Srivastava, Senior Director and the Vice President Advisor at the FPO. And we have with us the colleague, Professor Dr. D.P. Sikh, Dean of the Faculty of the Architecture, Planning, Design, Director, MIT School of Architecture and Planning. And the last but not the least, we are going to be joined by our external expert in the field of IPR, who's on the way, and Mr. Vikrant Rana, who's the managing partner of the S.S. Rana and Company, which is a premier intellectual property law firm in India. And this firm has been recognized as the award-winning and one of the best IP law firms in the India. And he has successfully mentored many aspiring lawyers and the IP practitioners. And he has been associated with the MIT for long. So I'm sure that his inputs will be much useful. But since all of you were there and the participants online also, so we decided to start this workshop. I'll not take much time. I am very sure that this interactive workshop will be much useful for all the researchers, and rather it should provide a platform to the faculty members and researchers to get directly connected with our IPR cell also. Because many a times it happens that they would like to know how to go ahead about it. So probably I remember when we were doing it last year, first time, so we had to ask that what are the formats. Then we got the formats. Then I had to ask a faculty coordinator to work upon that. So probably one needs the hand holding in the beginning year. So maybe possible in the days to come, IPR cell, and you have to take the initiative to take it to the institutional level. That will be much need-based according to me. That if there's interaction started, so people will have the query. So I hope that the interactive session will be much useful once the question answer session happens, once we are through with all the lectures. Thank you once again. Thank you.
Now I call Dr. Chandreep Tandon sir, Additional Pro VC and Dean Faculty of Bioscience and Biotechnology to address the guests. Please, sir.
Thank you so much. My esteemed worthy colleagues on the dais and off the dais, esteemed faculty members, scholars, I can say a few scholars also, I presume few scholars. It's good to see, firstly, outside this hall is almost full. I really appreciate that. Credit goes to not only the deans and the heads, but also the faculty members and the scholars who are here. Well, this idea of IPR workshop came into our mind around 2 months back. Then I contacted Dr. Smita Sahu, and I also spoke to various deans in the university. We have 14 domains. So we thought, let's have this IPR awareness workshop. I know everyone knows about IPR, but there's no harm in adding, giving addition to your knowledge. It's always good. And that too from the people who are into research and who have seen the transformation of research from publication to patents. So having said that, of course, Dr. Smita Sahu will be telling you everything about patents. I will not devote my time towards that. I just want to, narrate my own experience with patents, or patent, I would say, my very first patent of my life. I just heard Dr. Pradeep Joshi saying that last year only they started filing patents. And he also mentioned that we need, now people to handhold us, which I really appreciate, Dr. Joshi, because this is high time that we should be focusing on innovations, and innovations culminate finally in patents, technology transfer, commercialization. Of course, publication is also one of them. Having said that, the reason I quoted Pradeep Joshi is because what I want to say now will make some impact on what I want to just express. Many years back. Hello, please. Please. So let's welcome Mr. Vikrant Rana, Managing Partner of SS Rana and Company. Vikrant ji, we just started. Yeah. I'm Chandradeep Tandon. No, it's okay. It's okay. So I take care of, I'm Additional Pro VC of Research. This is my brief introduction. I just started. So I was just telling all our esteemed faculty members, scholars about the importance of patent in today's world and the filing of patents. What is the point of having this workshop? Many years back, when I had just come back, I did my postdoc from the US. When I came back, I got my first PhD student in the previous university. And believe me, I had no clue about patents. Very honest confession. We were just hooked on to, we heard about patents. Patents kya hote hain? We knew what patents are, but never realized the importance of patent or patents for that matter. I was just, focusing on publications, as any researcher would do, and the impact factors and the Scopus, Web of Science. These things, I've grown in the atmosphere, so these things are my tips. I remember many years back, I was given, few students, sorry. Sorry. So those students were, like students, they do their projects and they are associated with the faculty members. This is my previous university, not MIT University. So I gave them some project. Of course, since I'm in the field of biotechnology, project was related to biotechnological, some intervention, some technique. We all know what proteins are. Proteins are known to everyone. Proteins, carbohydrate, whichever field you are in, we know what proteins are. So there is a technique to visualize proteins on a gel. So simple as that. So when I was doing my own PhD, you know what is henna? Henna Hindi में क्या बोलते हैं? Henna is mehendi. Mehendi is used to stain hands, feet, even hair. Okay. So I thought, if henna can stain proteins on our hands, why can't henna be used to stain the proteins which we are using in biological work or biotechnological work on the gel? Because we used to use some other dye. उस dye का नाम था Kumasi blue. You don't have to worry about Kumasi blue क्या होती है. It's a dye. It stains the proteins. Yet worldwide, this technique is used, there's a gel, you know what gel के ऊपर proteins होती हैं. How to visualize proteins? You put Kumasi glue. So I thought instead of using Kumasi glue, why not to use henna? मेहंदी use करके देखते. So I started using that mehendi. It's called henna. उसे उसका botanical name होता है Lawsonia enormis. But I don't want to scare you about these names. Just मेरे mind में आया तो मैंने बोल दिया. I worked on it, failed. We tried for 1 month. We miserably failed. Couldn't get. Then I was getting worried. How come when henna can quickly stain my skin, even the nails or the hair, why can't henna stain the proteins which are present on the gel? So I told my students, they were in third year that time, B.Tech third year students, let's change our protocol. So they changed the protocol. They did lots of research. We used एक alpha use होता है red color. We used various kind of dyes. किसी से बात बनी नहीं रही थी. So after doing some modifications in our procedure or the protocol or the method or the methodology, whatever you call it, we did some addition. We changed the pH. pH, you know, acidic pH कम होती है, वो ज़्यादा होती है. So we changed the pH. This small thing. Believe you me, I was going back. At that time I was in Solan. I was traveling to Chandigarh. It was Saturday. I just got a call from my students where they were thrilled and ecstatic. They said, "Sir, we've got results." I immediately turned around, U-turn mara, and went back to my lab. I rushed and I was amazed, shocked, I would say. Positive way shocked, not negative way. I was ecstatic, euphoric. I'm using all kind of adjectives now to see that henna stained the gel, did the proteins on the gel. So मुझे अब लगा मैं करूं क्या next? You know what I thought? Publication. Again thought of publication, very high impact factor journal. Then someone told me, what about publications? Go for patent. Now, how to go for patent? This I'm telling you, 2003. 2003. इतने साल पहले की बात बता रहा हूँ मैं. So what I did, I went to my vice chancellor and asked, what should I do? He said, start finding out the process of, we don't have any IPR cell. There were no IPR cell, new university that time. मैं यूनिवर्सिटी की बात कर रहा हूँ. I was in JP University. You know JP University का नाम सुना होगा. I was in Solan JP University that time. So there was no provision of IPR cell. We don't know anything. Smita ji हमें कुछ नहीं पता था. Here we are, you know, lucky to have you and IPR cell, as Joshi ji just praised also. So Rana ji, we had no IPR cell. So what I did, my vice chancellor told me he knows some patent attorney in Delhi. He gave me address. He said, but you have to help him. I gave him a call. He said, fine, but there's a biological kind of things. You have to give me lots of data. You have to help me. I said, okay. So I started helping him. He said, सबसे पहले होता है prior art search. This thing was new for me. What is the meaning of prior art search? I'm just telling you my honest confession. I didn't know anything about patents. He told me what prior art search is. He told me, you do it. We will also do it. We did that. And after, I guess, 4 or 5 months of extensive hard work in this process, I learned a lot, Smita ji, which you're an expert. I learned a little bit how to file a patent. मैंने नहीं किया, patent attorney did it, but I learned from him at every step. He used to give me call, ये भेज दो, वो figure, this protocol, ये करो, वो करो, बहुत सी चीजें हमारे से मांगी. And finally, patent was filed. We were very happy. The moment patent was filed, so Vice Chancellor said, new university, let's put it on the website. It should keep on scrolling from left to right. Patent filed by on this. वो भी शुरू हो गया. That process started. It was 2003. The big thing. Patent file करना. I'm just telling you my story. And after 4 or 5 years, not after 2 years, I came to know it is now being published. I thought published. It's coming back to the square one. He said not published in a journal. Published in that वो जो patent official patent journal. Yeah, Gazette. So I was so happy, publish हो गया. Then मेरे mind में what is the impact factor of this? So there's no impact factor for that. Then itself is, you know, it's very accomplished patent, official patent journal. As Rana ji also said. And after 3 years, I got to learn the patent has been granted. And it was not only me who was so thrilled, whole university, the deans, the faculty members were so happy. The first patent from this university, उसको भी हमने left to right घुमाया फिर site के ऊपर. I'm just telling you the importance of patent. We didn't know what patent is. After that, I realized the importance of patent. Then you know, wherever I would go, people will come, people will tell me, why don't you come, you know, tell us about your story of patent, जो मैंने आपको बताया. मैंने आपको briefly बताया, you should tell me in details. That's what the patent is. And in today's world, I'm telling you, publications are fine. And even for the successful completion of PhD, we need to have 1 publication, 2 publication, depending on the category. We all know that, right? In Scopus, because NRF says so. But patents and commercializations, they play a very, very important role. So I would again suggest to you, Ms. Mehtaji will be, further emphasizing that filing a patent and going for a patent and getting a patent under your belt, it makes a difference because it takes time. And I feel more proud of the fact that उसके बाद मेरे पास और patents भी आ गए. But how can I forget my very first patent, which I just told you? So patents with you under your belt definitely makes lots of impact, increase your confidence level. Publications तो मेरी बहुत हैं, मैं publication की story में किसी को नहीं सुनाता हूँ. Always tell story of the patent. So with this, now I'll just hand it over to my colleague, rather our guest, Mr. Vikrant Rana. He will be sharing his experiences and educating you all. And we have very strong IPR cell. And in April only, we got to know that from Captain Shukla's email sent to all of us that our 429th patent has also been granted. MET has, to its credit, 429 patents granted, sir. This is the current scenario. Am I right, Smita ji? And many more have already been filed to the tune of 2,500 plus. 24? We are very close to that. 2,500 jaldi hone wala hai, bol diya. Bhushyawani. Thank you so much. Thank you so much.
So, if you wish, Dr. Kandan, you want to see and take that seat so that. Yeah. Yes. ये इसको बुला एक दो चेयर और
A very good afternoon to everyone. It's a pleasure and a privilege to be back at Amity. I used to teach IP law to ASD 4-5 years ago. So I had a 3-4 month semester, which I had taken for IPR for design students. So it's good to be back. And Amity, I've had a very long association. I'm also a professor of practice from the law school at Amity. And it's great to see the numbers which you shared, all more than 2,400 patent applications with more than 450 granted. So that's a big number for an academic institute to have that kind of number. And I think this workshop is also to lay the foundation of more patents coming from this particular department. And I certainly look forward to be part of that and how we can, sensitize faculty, students about the importance of patents, and not just patents. I'll also cover designs and trademarks also. So IPR, I'll just cover very briefly what IPR is. IPR would cover trademarks, patent, designs, semiconductor layout, GIs, trade secrets. So these are different aspects of IP, which can be in a single product also. So the name is the trademark there. You have the design, the shape of the product is protectable as a design, right? And then we always have a patent, like a run flat tire is patentable if it is new and novel. So what we see, and normally when we are filing a patent, maybe not for biotech, but for other mechanical or electronic, it could be that the same product what you're making could have a design element also and a patent also. And therefore, we need to file both of them to get protection for both of them. In academics, why should we do that? I think we had a very good example from Tanan sir about how his journey started in 2003, and it actually used to be very difficult to sensitize academic institutes. It was always to publish papers. I started in '99. That's my 27th year now, 28th year now in the profession, and we used to go to small towns, big towns, academic institutes. And they were like, we want to publish papers. So Dr. Mashelkar's very famous saying, publish and perish, patent and prosper. So that is where we have to go, that, we need to start filing patent. And patent, luckily, India is at a very good juncture right now. We had, for the first time last year, we had more than 100,000 patents filed in India for the first time ever. And a bigger achievement was that for the first time ever, we had 52% were local filings, which we never had. We always had a majority, almost 70 to 80% would be foreign filings. So all big corporations would be coming and filing their patents in India and then exploiting it, getting royalty, and probably sending the royalty back to their mother countries. So now we have the patents being generated, created in India and monetized in India also. So I think I would see as a IP ecosystem, filing patent is the first step. And then we go to monetizing it. Not all patents may be monetizable, but which is okay. The idea right now, where India is right now, the idea is to get people aware of IP laws, aware of patents, so they know probably not the first one, probably the second or the third one, they would be able to generate money from there. All the big institutes, Harvard to MITs and all these institutes, they have a major chunk of their revenue is coming from the royalties of the IP they have generated, the students and the professors which they have generated. And we at Amity should also be looking at, having that kind of a revenue from the IP being generated here. And for that matter, we need to be very vigilant that we file and protect those patents and other IP rights. So protection of innovation is there. Encouragement for investment, because I would invest, any company, entity would invest in that particular country or in a product if they know that product is secure, that they have a monopoly for a certain period of time so that nobody else can use it. I will only invest in if you have to invest in a company, you would see what kind of a patent portfolio they have. Do they have monopoly? Can they block their competition away by using a patent? So all IP rights are a monopoly of a kind. So you have 20 years right to use that technology to the exception of all others. So nobody else can use the technology, only you can use it for 20 years, right? So you have a big time frame with you to use it and have exclusive rights and royalty there. Facilitation of collaboration, because you have patents, you have designs, other entities may need it, they may require it as a license, or there could be a chance to collaborate because they're also doing some research and you're also working on a particular domain. So there would be a chance to collaborate and have joint royalties and licenses from them. Commercialization opportunities, then that is where the monetization comes, that once a product which can be sold or which there would be a need for the public, it can be commercialized on a basis. It could be a license to an entity to produce and share the royalty, or it can be sold off. It's like any other property. You can license it, like rent a house, or you can sell the house. So it can be dealt accordingly. And supporting startups. I think you mentioned about the delay and all. I'll cover it later on. But the Government of India has a very good startup scheme for startups and incubation centers which are incubating these startups. There is a scheme not only to reduce the filing fee, but also to expedite the grant of patents. For a startup, we have had patents granted in 7 months, which is the fastest anywhere in the world. So, I mean, and this goes also for the education institutes. We can expedite grant of patents to 7 to 12 months easily, and startups or a woman applicant. So if there is one of the applicant is a woman, the whole process can be expedited. You can get a patent granted in less than 12 months. So which is very quick as compared to any other country. Even the US, we are much faster than that. Benefits, I'll go very briefly. I mean, I wouldn't want to touch much on that, but the basic premise is the exclusive right. Like I said, monopoly. So you have exclusive right in the patent there. incentivize new ideas because you protect, you're able to monetize, you'll generate money to invest back into that research. So that research continues and it goes to the next level. Attracting investors, enhancing collaboration. Copyright, again, safeguards the research papers and software generated, promotes sharing while ensuring credit. So as a person who would be publishing papers, when you're publishing, you have a copyright in that content, and you have to be given credit to what you have written. So you have a moral right in what the content you have written. You can monetize through licensing, reduce plagiarism, and open access also. Industrial design is the aesthetic sense of the product itself, be it a pen, bottle, anything which is differently designed, which is new, novel, can be protected as a design. Incentivize appealing designs, and it provides a market edge. I always say when I go as a customer to buy a product, the first point of contact is not patents. I really don't care how many patents have gone in an Apple phone, but it is the design element. And that is where you all come in, that design is what would distinguish a product from any other product. And the second may be the trademark. I would want to buy this bottle. I don't know what brand it is, but the shape tells me this is a particular bottle. So that would help you to distinguish your products from others. So for the customer, the design and trademarks are first point of contact, then a patent.
Sir, sorry to interrupt
Brand
you.
recognition, consumer trust from trademarks, and revenue generation, surely. Evaluating ongoing research and projects for potential IPR. So I think it's very crucial for any entity, be it an education institute or a commercial entity, that a regular IP audit is conducted. It could be that we could be sitting on something, a lot of research which has not been patented, which is yet to be published, and it could still be patented. So that regular research is required to be done.
Sir, sorry to interrupt you. Am I audible, sir? Sir, am I audible?
So that we are able to identify, recognize, and understand if these can be filed as a patent or a trademark or a design, and file for those before they lose their rights. So design and patents are two things where novelty is very crucial. Novelty is that it should be new, and newness is considered on a worldwide basis. So it cannot be that there is somebody has done some work in say USA and nobody has done it in India. You bring that design and bring it to India. You cannot do that. So they will check the novelty. If it is done in USA, you cannot get a patent or a design on it. So similarly, when you are working on any project, you need to first file the application, be it patent or design, and then make it public. And public is not just publishing a paper, but even on a website, even discussing with vendors or others, market confidential, say it's privileged and confidential, and file the application before you put it anywhere in the public domain. So identify, like I said, IP audits, identify the inventions, creative works, designs, brand elements. And there would be, like I said, that example of a car, any product can have different facets of IP. So we need to have the right person to identify and see if what all can be protected there. Prior art, I think sir mentioned about prior art. Prior art is what is the state of the art at present before the invention is conceived. So that is the base, like this is the problem right now, and you conceive the invention over and above that prior art. So that is the starting point. And that's a huge resource to see what is the current state. At times, so many inventors come to us that we have come up with something new, but they had not gone through the patent databases. That is a mindful of information there, because you could be reinventing the wheel if you don't check those patent databases. Most of them are free. Indian patent database, European, US, these are free to use. Google patents. And you can check what is the current start. I want to look at, what is this mouse is there? What kind of the current patents for mouse? And you will see number of advancements already there. So it would help you not to invest your time, resources in something which is already known. Rather, you can see what is the current state of the art of the patent applications. And because the patent application and the actual product, there is a gestation period depending on a product from 6 to 12 months or probably longer. So it may not be in the market now, and you may think you have done something good. So, but it's better to check the patent databases. There could be something which is already filed as a patent, but not in the market. And base your search from the patent databases that this is the current art and this is the problem even after this patent has been filed, and I want to solve it. So the starting point has to be the search conducted of the patent databases so that we can enhance and improve from there. So that is the prior art, and we build on that prior art. And again, prior art is not just limited to the patents which are filed. So at times we think, okay, whatever patent is filed. No, prior art also includes any articles or papers you have published anywhere in the world. So you have to always check the patents literature and also the prior art in the sense of which are published papers anywhere. So literature review is very essential for that. And then you have to check for patent. Its novelty is very crucial. It has to be new, like I said, across the world, not limited to India, but across the world that should not have been created. Non-obviousness, evaluate if it is sufficiently, that incremental inventive step is there or not. Evaluate also the commercial potential. Is it really commercially viable or not? And at times we have seen that academic institutes or students, they are maybe writing papers or also investing in invention which may not be commercially viable, right? You are doing something, but it may not make sense commercially for the markets. So the market and the commercial entities and academic institutions have to work together to find what is the gap in the industry. And that is where the revenue will come. Because if you work to find the gap in the industry will be willing to pay you revenue, the royalty for that. So that is also important to see the market analysis. And competitive advantage. Determine if the IP can be provide a competitive advantage or not. If it is something common, you will not have that advantage. And so advantage will come from securing the IP rights in that. And therefore, they have to align with the goals of the institute. What are we looking at? We are looking at building a portfolio and eventually licensing, monetizing the resources which we have developed in the form of IP rights. And also look at collaborating with other institutes or commercial entities for the opportunities in licensing or assignment. Like I said, many of the foreign universities, they are actually earning a lot of revenue from the collaboration with industry. And unfortunately, though now it is changing, the interaction of the industry, academia, and the government was not that great. Now the triple helix model is there, where the government is also supporting and the industry is also talking to, like IITs, they have the incubation centers where the industry is investing, sponsoring, where industry comes and tells, okay, this is the pain point we have, how can you help us? And where the researchers and students and the faculty help in answering that question, which not only gets them a patent, at least the name on the patent, but also the royalties and the monetization of the royalties. So that collaboration with industry and the government plays a very vital role to monetize. Again, then the question is also to engage the legal counsel at the right stage. Like you said, you had to really look around and find, and probably at that point in time, 2003, there were not many people in that domain also, but now it was a new university also. So that information awareness was much lesser. Thankfully, now it's much better. And in fact, the IP office has a list of IP facilitators on the IP office website. I mean, thankfully, we have a full-grown IPR department here, so we already have that thing. But for startups or individual, for startups, you can actually refer to the IP website, IPO website, and you can approach any of those lawyers or patent agents, and they are supposed to do it free of cost. The government of India pays them for filing the patent applications and prosecuting. So there is no fee charged by any of the lawyers for filing the patent application. So that is a big advantage. And you get, like I said, 80% reduction in the fees for patent applications by a startup, 80% reduction. That's a huge benefit for startups there. And legal counsel is not only just to analyze and see if it can be filed or not, but also to see the collaboration, the licensing agreements, with the vendors, with the inventors, so that there is no gap when the final right is accrued. Record keeping is very essential, that you were the first ones to do that. So when you're doing your research, proper record keeping should be maintained. Then prioritize IP filings. Like I said, you have to file first before you make it public. And similarly, we have a concept of a Paris Convention or a PCT, where we can take this application outside within a period of 1 month, 1 year, and which can extend up to 30 months. So even if I file it on 1st of January, I have time to complete the specification. So there's a concept of a provisional application also. Provisional means that I have done some research. It is not complete, but I think it is some groundbreaking stuff. I can file an application as a provisional to get my foot in the door. So I will get that 1st January date. I get that. And then I have 1 year to do my research and then expand on that application within the scope I have given. So I can actually expand into that, get my date, which is crucial, because if anybody has done that work on the 2nd of January, I would still be senior to him, right? And this is 2nd of January anywhere in the world. Even if they do it in the US, you are still senior and you can stop them. So that your foot in the door by filing a provisional is very crucial. You have 12 months to complete that application. And ongoing evaluation and review of IP portfolio. It's important to see what IP portfolio you have, because you have to also keep renewing the patents which have been granted. Every year you have to pay a renewal fee. So considering, do we renew or not? Do we let go? Should we license? Should we sell? So that should be a recurring activity every year, at least it should be done. Best practices and guidelines, I would say educate on IPR basics. And I think this is a very good step by the IPR group here, that we are doing this to sensitize about different IP rights, and we should be looking at protecting the IP rights. So that is there. Institutional policies, IPR policy. We have an IPR policy at Amity, and everybody should be aware, and they should know how it goes about the filing procedure and all. Document research and innovation. Like I said, maintain proper diaries and record keeping for that. Prior art searches is crucial. Do not start researching something without doing it, because after 6-7 months, we'll get to know this is already done. It is in public domain, and we have wasted resources and time on something which could have been avoided by looking at the database. And engage with IP experts. File for protection immediately. Collaborate. Commercialization is there. Once you're granted, then you can do that. And monitor is, like I said, for IP counselor, it's not just filing or the contractual, but also to keep an eye on what the other competitors are filing. So the patent journal, the gazette comes every Friday, and you have to keep an eye. I mean, you or through your local, the counsels and lawyers, you can keep an eye on what is the trend, who is filing what. So what is the state of the art now? And you can keep a check on that. And if required, go for a cancellation or an opposition against somebody. And then also to see what is happening in the market. It could be that the product you've developed, somebody could be copying it. Then you need to check on that and take action, take suitable legal action, and claim damages for that misuse of the product also. I'll briefly touch upon different aspects of IP. I won't take more than 5 minutes, I hope. So these are some designs, I'll say. So very good example, I want to always share that, Walkman used to be there. And after Walkman also, there were USB sticks. I don't know if people know, there used to be like 600, 700 rupees USB sticks. May have a screen, may not have a screen, and you could store a lot of songs. But then iPod came. iPod was basically the same USB stick, but really fancy with the design. And it was the design which got the premium to Apple. And Apple products are purchased, for design students, I don't have to tell that, it is for the design element itself. The premium you get is because of the design, because of the work done by the designers. So we can see how they have actually grown from there. And this is, I just wanted to share, if people have gone to an Apple store, I think probably outside India, this staircase is very well-known part of the Apple store itself. And it was designed by Steve Jobs himself. And this is without any pillar, a standing staircase. And he got a design register for that. So design has to be original. It has to be novel, and it should not be registered in any country. So like I said, it has to be totally novel on a worldwide basis. These are some designs of buildings, I mean, which have been registered. You can see that garages and other buildings. This is from Japan. Then we have another one from Tata Steel. They have a prefabricated interior structure. So these can also be protected as design. So if you are doing something like this, please take a look, talk to the IPR cell before you publish anywhere and have these filed as designs. This is a water purifier of bed. So these products can be there. And these are filed by Amity Design. So university, refrigeration unit, funnel attached burette. So these small things also, any small change can also be protected. So don't think it's a too minor a change to actually get you a registration. So always worth a shot to try. And obviously after conducting a basic search and file for those small changes also. But only thing is, sorry. Congratulations. So we have the person here right here. So congratulations for that. So only point, like I said initially, was that when you're filing a design or a patent, please check that would it also include something on the other. Like I'm filing a patent, please check, does it also need to be filed as a design? So patent will be for the functional aspect, how it works. Okay. But the design will be for the aesthetic sense. So that can be protected there. So what does not qualify? Copied, functional, obscene ideas, these cannot be registered. I'll skip this. So only design protection, design with functionality, you can get design, and only functionality will be patents. That will not be covered here. It's not mandatory to produce. Sometimes we have this, that do I need a prototype? You do not need a prototype to file a design. It can be done on a computer drawings also. So keep that in mind. You have a prototype on drawings, we can file it. It is a finished article which is registered. It's not I want to file for a fridge. It cannot be the inside of the fridge and outside. It can be only one. So normally it will be how it will be from outside. But if we want an interior view, it will be a separate design. This is there. So top applicants, Indian. These are NID has filed the maximum there. We have SPS filed. So a lot of universities are already filing a lot of designs. And copyright here will be limited to the literary work which we are publishing. So copyright is bestowed automatically. I don't have to get it registered, but we still advise registration so that tomorrow, if there is any issue regarding the date of publication, so that date is secured by filing with the Copyright Office. And copyright is not on the idea itself, but it is the expression of the idea. I can say, I thought of this, that doesn't work. It is how you express the idea. So that expression will be the what is protected. Important thing here is who owns the copyright. So there is a difference between authorship and ownership. Author is the person who does it. I have written a book, so I am the author. But if I'm at Amity and as per my contract, the IP done by me will be with Amity, then Amity will be the owner of that, whatever work has been created. So the ownership and authorship are two different things. Similarly, if work is done for work for hire for an employer, the employer would have the right, unless it has been specifically excluded from that. So those agreements and contracts are very important. I can skip this. Trademark. So normally, I mean, trademark was not part of the thing, but I thought there is a very important aspects of trademark from an architecture point of view. So these are the different kinds within a trademark. Kellogg's, the style of writing F, not F, but the style of writing F, numbers. So famous buildings which have got trademark registered. Apple Store, the distinct layout of an Apple Store is protected as a trademark. The Seattle Needle, Space Needle, that is protected. The architecture, the shape itself is protected as a trademark. The Sydney Opera House, that is protected as a trademark. Our own Indian Taj Mahal Palace Hotel in Bombay, the structure has been protected as a trademark. So we can also look at, so the difference, the major difference between patent and design and trademark is patent and design is before it is made public. And trademark comes in when it's become very distinctive of that particular thing. So when Taj Palace Hotel is, when you see a photograph and it immediately gives us the image that it's from the Tata's, this particular hotel, so that it becomes distinctive, then it can be registered as a trademark. So all these buildings, after use, after being in the public domain, they got so connected with that particular entity, they were able to be registered as trademarks. So from an architecture point of view, does taking picture of buildings constitute infringement? So when you make a building, can that be done or not? So EU has a right, panorama right? So the exception is carved out that, if you click a photograph, which is for non-commercial purpose, then there's no issue in that. And similarly for India also, there's an exception that if the building is in public domain and you click a photograph for non-commercial purposes, there would be no issue of an infringement there. But then you can also go under, like I said, the trademark law there. So there'll be a issue of overlap of copyright, trademark, design laws. So whatever best suits you to protect the right, you will take lead of that. Patents is a exclusive ownership for 20 years. Patentability, conditions of patentability are there. And why register a patent? Avoids duplication of research. Latest development is cutting edge things there, and help the industry as a whole and a country as a whole to move to the next level. And also serves as an indicator of achievements in R&D. Like I said, 52% of patents filed in India are locally from Indian entities. So that's a big one to indicate, and which really helped India to get onto the innovation index that we are rising on that particular scale. Granted patents, again, this is a facade system which has been granted patent. Modular pre-construction assemblies. So we saw that design also, but how it has been made, the functionality, the process can be registered as a patent there. So these were some examples I thought which we connected to what we are doing here. So I'll be happy to take any questions on that.
Vikramji, one question is regarding the Taj. Can you put this like the Taj Mahal hotel?
Yeah.
So you said it has got the trademark protection in India.
Right.
So does that mean that no one can copy this architecture design?
So yes, I mean,
This?
yeah. So basically, this was done for the commercial purposes where postcards, keychains, all those stuffs are being made where they put the photograph of this. So that could come under copyright plus the trademark on that.
So if anyone copies this, then the same
Right,
architecture,
right.
that is then that is not allowed.
That would be infringement. Yeah.
But now tell me, there could be the same architect.
Right.
As to tries to replicate a similar kind of a structure.
Right.
Structure in some city. Like we are giving an example of we have Dubai campus.
Right.
MIT campus. So these things we invested it together. There's a new campus in Mohali, Chandigarh.
Okay.
It is not exactly same, but it looks almost similar like that. What the architect was saying. So the idea, crossed my mind. This question when you said.
Yeah.
So is it allowed or not?
So, I mean, they would normally, if somebody has done, first of all, we need to have proper agreements regarding the rights which are flowing from it. If we are engaging a vendor or an architect or a supplier, then the IP rights have to flow to us. Like I said, the authorship and ownership are different. So he may be the author of that work, but when we have commissioned that work for Amity, then it has to be owned. Any right related to that would be part of it. And it could be part of the clause that you will not replicate any design which you have done for us. So that should be part of that design itself. Secondly, when normally an architect would have done, they would have made some slight changes to avoid that kind of an issue. But still, this thing is still not that big in India. Gradually, when people get more aware and all, so they can use trademark and copyright, a mix of that to protect, because the drawings, the drawings of the building, they are protected under copyright also. So if they use the drawings, similar drawings, then they're infringing my drawings, which I have paid for, as Amity has paid for.
So that means, if awareness comes in India,
it would.
Everyone starts selling this kind of trademarks. That is going to be very challenging.
You'll get more creative.
Okay, question.
Yes.
Now, what is the role of this NFR? As we see, it's very difficult for that my design is copied somewhere in Austria, for example.
Right.
So it's very difficult for me to find that. So, how this NFR thing can help in this area of copyright?
So, see, ideally, obviously, as a right holder, you have to be aware of your right. If you have a house in India, is a simple thing but it's a house. It's a property is a house kind of a thing. So somebody is trying to occupy or do something with your property. You have to be vigilant. I mean, being in the same trade, you would know that somebody has copied or not in India or outside India, or somebody is doing that. So I think we did work for Vibhor Sogani, his a lot of architectural stuff. So somebody was copying it in different country or even in India. So the owner has to be vigilant. They have to that somebody is copying, and then they take action. But again, the rights here, because it is in Austria, have we filed that patent and design in Austria or not? If we have not filed, then it's free to use. I can rely on copyright as a third right, but otherwise it's free to use. The opposite of that is if some designer has done something in US or somewhere outside India and they have not protected that design in India, then it is kind of open to the trade, though he can rely on copyright law to prevent it. But otherwise, if they've not filed patent, it is clear that patent somebody else can copy that. They cannot stop you unless they're filed in India. For design, they can still rely on the copyright law to protect it. So, but the owner has to be vigilant. That is once you are there, then you can take action there. Yes.
I have one. What if anyone has copied mine, right, and been filed or has been registered here? In that case, I really take any action on that.
So patent, obviously there's no way. I mean, you can patent, you have not filed, you're out. Design, you have not filed, you're out to a certain extent. So there's a overlap of copyright and design laws in India. So we can go under copyright law because the design, it depends on what the design is. So for a product, suppose it's a, say the bottle, under the, there's a overlap, like I said, if a product which can be registered as a design. So bottle, the design can be registered, but it is not registered. Then, and not more than 50 copies have been made, then you can still get protection under design law, right? So this actually helps the designers. So Sabyasachi has made whatever dress he has made, and he has not made more than 50 pieces, then even if the design is not registered, he can take action. That is clear. But if now you have made more than 50 copies, then you are out, because the defense the other side would take that this is, they have not filed design and it is now more than 50 copies. But there's a recent Supreme Court judgment now where they're giving that, that you have to see the purpose of it. If it is for architectural drawings, then the 50 things should not come into play, right? So copyright law is where we can find some via media to take action, but we'll have to see what is it for a product. Then I think probably we're totally out. But maybe for artistic work, drawings and all, it may still work, but it'll depend on the fact. But that is the reason the whole idea of the workshop is that if we have a design, we need to file that. Why don't we file designs? Okay. Why does normally, so even when people are aware, they don't file because the cost for design is 1,000 rupees for an individual. And I think for institutes also is 1,000 rupees. But like we have a client jeweler design, he comes out with 50 design every month. And out of those 50 designs, probably 2 or 3 will go big. So I'm investing so much into it, 50 times into 1,000 to get out of which only 1 or 2 will really go big. So that's a big dilemma for people, entities having a large number of designs. So they're not able to file it. So India recently signed a design law treaty, and under that, they're allowing that there would be a grace period, that even if you have not filed a design in the first 6 months, you can do it within the first 6 months without losing priority. So if that comes in, so you launch a product, you have 6 months to see which design goes big and then file it. So that law will come, I think a couple of years will take, but that is the thing. But till that time, if we want to protect we should be filing that design applications. Yeah. Yeah. Yeah.
Question. What if, I mean, is there any percentage written or is there any quantification panel where there are percentage which has been copied and they have deleted?
I won't say there's a percentage. So design is totally aesthetic. It is the look and feel of the product, right? If I have this and there is a different mouse, which is similar to, if I look at it independent of this and I think it's copy, that would be considered copy. And it's a value judgment by the examiner also, and also by the judge. So it may differ from judge to judge also, because it's a value judgment. I think it's a copy, and it has to be a slavish copy. That the first impression is, yes, it's a take on this. That is this. So there's no percentage, but it would be, does it appear to be a slavish copy of the first one or not? So, yeah, ma'am.
Yeah, actually, you mentioned that the patent for the design patents, the prototype is not any.
Right.
So is it indicated as per the number of drawings
Right.
which is required?
Right. So, thank you. That's a very good question. So for a design, we need the 7 views. Seven, all the 6 views and 1 perspective view. Right. Top, bottom, sideways, left, right, left, everything. So 7 views have to be there if it can be, but certain products may not have 7. So we can file those and let the examiner.
Or have 10 or 3 visual.
Whatever depicts the design better. So the idea again is not to file a design for filing it. Idea is to, when I go to court to enforce it, can I enforce it with that drawing or not? Right? Aaj ke liye you want to file it to let me get it by a 2D, but tomorrow when I go to court to stop somebody, then they'll say this is different. So you need to think of that day when you're standing in a court of law, that it has to be something which is a copy. I can make out that it's a copy. So whatever is better, we should. Yes, please. Right. Right. Uh-huh. Right. The patent would be on the functionality. I mean, is it so? Patent also, because I mean there are a lot of apps now. So if we can show some interaction of the process, if there's a process, how it goes and how it can impact an app, how it can work an app, there could be ways to file a patent for that. So that can be explored. How we enforce it is a different matter. It may not be enforceable at all, but there is something to try and see if we can do that. One. Second is on copyright. You said, I mean, it's a project would be written, right? Test basis. So even Tambola tickets have copyright, right? There's a numbers only 15 numbers on 3 things. So they can be protected. So as long as you have done it, it can be filed as a copyright application. So nobody can copy the exact thing. The issue would be if they make changes and the questions are changed in a significant manner, then obviously they can get away with, because even for a software, I can get the same result from 2 different codes. I can code it in 2 different languages, 2 different codes, but the end result could be the same. So their copyright, I mean, you can't enforce that, but that person can also have the way he did it. It's your expression that is protected. So nobody can copy your expression. It's similarly like I go to a beach at 4 o'clock on a sunny day and I click a photograph, and you go on next day, 4 o'clock with the same weather condition, and you click a photograph, both are same. So both would have rights in it. Nobody can, stop you did not do that, because both created that work.
Just similar to this example that we have quoted, one of the hotels like Burjara Hotel,
Right.
It is designed by architects in London.
Right.
And I have seen that similar replicated form in Punjab. It's a G+2 structure of an office.
So again, the replica issue is,
which region law will prevail?
No. First of all, so again, for these kind of structures, there would be a combination of trademark and design. So copyright, we don't even have to file a copyright, like I said, but copyright would be in the drawings of that particular thing, right? Or a photograph of it that we can protect. Otherwise, it can be a trademark, a trademark on what the structure is. But again, it's the enforceability which is there lacking right now. People don't want to, or they resources wise also to follow up with taking action and all. It may not be easy because we have so many those parks with replicas, right? So they have the replicas of those structures. So that is there. So, but if they are, I mean, those structures could be stopped using the different laws, you know, the photographs, the copyright, the design. But again, at times people want, I mean, for publicity or for whatever reason right now, it's more of learning. So they want to share that. So that law has not developed to that extent to stop others. Yeah.
So you were showing the patents filed from MT.
Right.
This one was filed by Delhi. So can it throw some light on the authorship and ownership of that patent? For the medicine, that is open. First one,
So normally it is always bound by the IPR policy of the entity or the institute, and it would be owned by the institute. That's the default, unless there is a contrary agreement to that. So that would be the sharing or whatever would be as per the IPR policy, how it is, the revenue sharing is there. So the ownership, the name of the inventor would be, you know, people who invented it, they will get the name, but the owner would be the university.
So as far as grant is concerned, so is the grant associated with design or with some kind of design or product? Number. Or if I got my patent published for my thesis,
Right.
it was risk and reliability assessment model for fire safety.
Right.
I got the patent published as a utility patent.
Right.
Can I go for a grant?
Grant would grant
Design grant of the process, because what I got the patent is the process. How we assess
that is what I said. When we are filing that application, we need to be aware on the same day we have to file it. Otherwise, your novelty of the patent will be destroyed by design if you file design first. So if that product has both the components, as the functionality and aesthetics, then both have to be filed on the same day.
But this is not a product. It's a process, or it can convert into an application.
Right. Right.
Can I go for a grant? That's my question.
Grant, as in, it's not a financial grant.
No, design grant. Say, design grant of the application.
The application, the look and feel of the application is there. If there is
or the process. Because
process is patent.
Okay, that is the utility.
Function is patent. Functional is patent. Aesthetics, how it look is design. Yeah, is design. Design and copyright we get that. Yeah.
Okay.
So, because we have requested Dr. Rana for a specific time, and it was on very short notice that they agreed to come here. And he asked that because he has a meeting, he has to stop by these pictures. But I would like to tell, especially from the architecture and design institution, Mr. Rana started associated with MIT University.
Right.
I think 6
Yes.
years back.
Yes.
So once Dr. Ekta Singh, from the director, she came to my office and told that she has called a lawyer for some purpose. I was really like, you see what is it meant for? So she told that how he actually introduced this IPR thing in design, and I think first time that year, through him, we were able to file few copyrights at that time. So after that, I could see him that he was with the law department once when that professorship was.
Right.
And I was in that auditorium. And the beautiful part was that yesterday I asked Shalini, can you suggest some name? Again, she suggested your name.
Thank you so much.
And he's taking, like, he's traveling across India to help the institutions. I know that he's taking workshops in various institutions just to support the education fraternity about their rights, how to support them in this domain where they can monetize the thing. So we are not only as a design school, but as a fraternity in education sector, we are very thankful to Mr. Rana. I will request Dr. Kandan and Dr. Joshi to please step forward to facilitate Mr. Rana.
Actually, one thing I just wanted to add, is that sir mentioned about publication of papers. So you file the provisional application and you can publish the paper. So you can do it the next day. You don't have to hold back for the grant. So
Thank you so much.
pleasure. Thank you. Thank you so much.
I think you should call him again.
Yes, all the education fraternity is always a best plus out. Thank you so much.
Okay, thank you so much. Thank you.
Thank you. Back to all of Now, I will request a capacity building and augmentation of intellectual property rights by Dr. Smita Sahu. And she is the director with MET IPR cell. So always you can reach out to her for anything, any queries and helping your things done in IPR domain. So I wish that lots of questions should be coming from all of you to her so that when you go to her, you go prepared. So with this, I would request Dr. Sahu to take over. Thank you. Just 1 second.
Very good afternoon to all of you. It's my honor and a privilege to be here a part of. So before I start, a very good afternoon to our respected sirs here, Honorable Founder President Sir, Honorable Chancellor Sir, Honorable Vice Chancellor Madam. It's basically the vision, mission and mandate of our Honorable Founder President Sir to realize Amity University the topmost in research innovation. So I, Dr. Smita Sahu, serving in your in-house Amity IPR cell and extending all possible structural and function enablements to all the faculties, research and students to ensure augmentation of patent application filing and also towards establishment of a forward-looking progressive IP ecosystem in our university. So I think this problem, the very first one, I'll make sure.
Just 1 second.
This is the one, right?
Yeah. Yes.
Sorry.
So thank you.
No, it will come.
Be careful. It's good. As on date, as we have already been briefed by, as on date, we have more than 2420 patent application filed. We are not only in patent filing, rather we have a very diverse IP portfolio. We have more than 742 copyrights filing, designs, trademarks also. That has led our university to come up with a number of awards. So to name a few, in the year 2020, Amity University was bestowed with the National Intellectual Property Award 2020, followed by also, it's worth mentioning that not only Amity University, but our Amity International Schools are also performing quite well. With the visionary leadership of our Honorable Chairperson Madam, more than 120 IP have already been generated from Amity International Schools. And in the year 23 and 24, the schools were awarded with National Intellectual Property Award. So that's also incredible because of them. And apart from national awards, Amity University won CII, ASHM, Best Patent Portfolio Award, the best university with the strong IP ecosystem. So I think it's my salutations to all of you because you have really played a very important role here. So it's just our researchers and students and faculties. I will just give a little brief about, we have started filing patent applications from the year 2008. That time our Honorable Founder President Sir has a vision to file at least 100 applications in the year 2008 when not many of them were aware of the same. So gradually you can see it's a progressive trend over the years. And in 2025 also, like since we have further 10 more has been added here. So and that's a cumulative effect which shows the grant as well as the progression of the IP patent filing. 2420. 12 more have been filed yesterday only. So I will just quickly take, and also I'll not repeat what Sir has already covered. So as far as the campus-wise filing trend is concerned, AUP is the largest university with the largest contribution with 1719 patent filing. And then we have a number of other campuses also, followed by AUH and AUR, AUMP also. Schools also have contributed significantly with all the branches across the country. Now, if I'll take few minutes here, the domain-wise patent application filing, you will see that the largest number of patent filing contributions coming from the Faculty of Engineering and Technology, followed by Biosciences, Science and Technology, Arts and Humanities also. We'll discuss about that also. Agriculture, Health and Allied, and these ones. So that's already we have discussed about. That's your, as far as our Faculty of Architecture and Planning is concerned. Year-wise patent application filing from the this particular domain, we can see in the year 2023, 2 patent applications were filed, but afterwards, it's no contribution coming from here. And also we can see Dubai, Mumbai, AUH. So total number of filing in this particular domain is 6. So I think I'm here to serve you, and I expect you together will work together and to come up and ensure the augmentation of patent filings. That's few of the patent applications that been filed, like the assembly with a mobile for air purification, AI-based water motor, development of adsorbent. And that's the number of copyrights filed. And also, I am really grateful towards the Joshi sir's input and the facilitation that last year under the creative, we had filed 19 copyrights, and this time also 25 have already been there as a filing. So that's a copyright contributions. But we will discuss few of the case laws, few of the examples, how we can file towards the patent also, and also designs number of. That's the trend, although it's a very progressive copyright filing from this over the years. And I'm talking about only this particular domain only. That copyright contribution is from this domain. Granted over the years, as we have already seen for that. That's a small, I'll take again 10 seconds. That's a trend of our filing for a year in up till April. You can see the number of filings here, gradually increasing, like 40 in the last month itself. And in May, we have filed 48 applications. Because of positive time, I couldn't update it. And if you can see the number of grant in a hearing, we have a huge, like 31. And in a month, we have been granted like 19 applications. So it's just a quality filing from Amity University. And I have interacted many of you individually, but it's glad that I've got an opportunity to interact with you in a very, collective manner. And I would definitely want to share a few of my, the experiences, because I have witnessed more than close to 800 patent hearings so far. So based on how and what are the criteria that makes your application pass through the lens of the patent law successfully, we'll discuss on those. That's only the cumulative one also. That's the contribution of copyright application filing, 700 around. And also we have like trademarks and the designs also. It's known as industrial designs, not the design patents. It's industrial designs. And the NBA filing also huge. Basically deals with wherein the invention related to biological resources only. Now, since it's 1 second for that. So in The Dark Knight, the Joker said, when you are good at something, never give it for free. The kind of, the effort, money, and your, if goes into a patent application filing or any of the IP, filing, please take the maximum out of it. DITT is there, Director of Innovation Technology Transfer, and also the tech is there. Technology Enablement Center, which will help you to upscale the TRL level, technology readiness level, and get the commercialization one. You have to just seek the relevant departments which will help you to a long way. Even the copyrights and designs are equally, worth commercialization for, and you'll get the licensing fee and also the fee for. Now, it's a small example of wherein it shows like it's a multi-healer of a CIPLA. I'm showing how one particular invention or product gives you a number of, the safeguard of the IP. Like here, the patent, as already discussed about the functionality, if it is, fulfilling the novelty, inventive step, and Section 3 criteria, patent is being filed. Now, second is trademark. As we know that trademark basically, any kind of which makes it visible in the market among different other products, and design only external aesthetic aspect which appeals someone to buy it. And confidential information are known as trade secret, which you keep it, right? And at the time of commercialization, you bargain it with, right? And then there is a copyright, which is basically a leaflet. If there is a medicine box, a particular, paper leaflet is there, which indicates the dosages and ingredients. That is also copyrighted. So that comes from that. Now, I'll start and show you few of the, because these are the kind of queries I get it from this domain. So I'll just enlist few of them. Like, as we have discussed about the copyright is a bundle of right, which is given by the law to the creators in number of, the area like literary, dramatic, musical, artistic, cinematography, and such, the wider scope. And what are the subject matter? Original literary work, and computer software on disk, dramatic work, musical, audio, the visual work, and artistic work. And there is an exception that's known as fair use, right? Like, for example, if any faculty goes with the preparedness of a lecture, of course, I take the excerpt from different books, different newspapers, different articles, but I'm not infringing someone's right, because I'm here to enrich the common man. That's the public, the fair use. And also the newspaper readers, or the kind of, the coverage I'm taking article. So they are also into the fair use. Now, these are the ones in this particular domain. I have categorically indicated what exactly comes from. Like, for example, if there is in painting, right? So the copyright protection for painting applies to the moment it is being created, right? And in tangible form. It should be copyright is granted and secured for expression, and that too in tangible form. So it includes whether it is on canvas, whether it's on watercolor, acrylics, or any digital painting as well. Now, coming to sculptures, which basically again range from traditional stone to the metal works to contemporary installations that are being projected. Photographs, this includes both digital and analog photography, where the copyright protection covers the entire subject matter of a photographer being taken. Illustrations, graphic works, the architectural works, the printmaking and engravings also, performers under the cinematography work. Now, graphic prints and textile designs, yes, they can be in the fashion. A lot of graphic designs been there. We know about the unique floral pattern of, could be Burberry, Gucci. So that basically differentiates. Unique garment designs, basic cuts and designs, they cannot be patentable if a normal basic cuts, but something which you have enhancing, that appeals to somebody to buy it for. So that are the subject matter. Even jewelry designs, the custom fabric and the lace pattern, these all are patent, copyrightable. Limited edition pieces, sometimes we come up with a limited edition that can be. Even for footwear designs, unique kind of footwear designs like the Crocs they have, or sometimes any, these can also attract. The luxury brand, the original garment designs, seasonal collections, fashion illustration and sketches, could be 3D, 2D, any design tools, that all are. So why do we have a valid copyrights? Originality of an authorship, fixed in a tangible form, no copyrights on facts and ideas. It's only in the expression, not even for short words, right, and slogans. Now, what are the rights covered? As we have discussed just now about the kind of rights being covered, right? That's basically once a copyright is being protected, you come with a bundle of rights. And those rights are right of performance, right of translation, right of adaptation, right of reproduction. Like means how a particular project, if a book, Harry Potter book is there, you can maybe make a movie out of it. You can stage play on that. But original consent is required from the person who has authorized it. She may give you, are charging you that. So these are known as derivative works. If I've written a book in Tamil, you can translate it in Sanskrit. That is possible. You can get that. But my consent is required. So these are the sets of rights which will come to you that are known as economic rights. You will earn it. You will earn through your work. Now, another one is moral rights. Moral rights is something which will be retained by you. Even if you are commercializing it, exclusive or non-exclusive, but the moral right will always be with you. What is it? No one can, take away with the essence of your work, right? Because that is what you're meant for, right? So these are the one. So exceptions we have already discussed. It's not a perpetual in nature. It's after life of an author, 60 years. After life, so we can see a lot of Shakespeare books selling in the nice market and all those already, crossed that line. So afterwards, any publisher can, print that. I'll take one small 30 seconds on this picture. That's a very famous case. That's the monkey selfie, right? One Slater was there. He was a photographer. He was just lying, and by the wink of a time, he took this monkey took the camera, took the selfies. It came out so nicely that he got it published and getting the commercial benefit out of it. Now there are human rights, animal rights association also. So they said, so basically for any of the photography, you know about it, no? If your picture is being clicked, you are not the one who will enjoy the right. The person who has clicked it, the rights will belong to the person who has clicked the picture. So likewise, since the monkey has clicked it, so they said the copyrights and all economic rights should go to the monkey. But eventually here what they can do is the society was formed and for the benefit of that community. But lastly, the Supreme Court stated that in the copyright law, there is no provision of animal being enjoying the right. So eventually landed up in the. So listeners, even in Facebook and Instagram, you're putting up the pictures, make the due courtesy. Now, few more, like in case of Houseful, there, there was like some song of, Apni Jaise Taise, you have heard of. So that was being taken from the Lavaris in the Houseful without any consent. I told you, you come up with a multiple bundle of rights now, but consent of the original author is required, but that was not taken into. So it's for a case. Another one is DU photography case. I think you must have heard of, right? DU photography case. That was also one of the things wherein I'll not take much, but small, like DU has contested that usually they are for a, aided students. They cannot charge for a huge foreign writer's book, like in our cellular, like D. Roberts' book is there, which is being sold in 4,000, right? But they cannot buy it. So basically they used to photocopy the book. So who is at loss? The publishers. So they contested, how come the photocopy shop being sold by this, because we are losing our business on that. The final verdict was on the basis of fair use. They said that students are from the economically backward classes, they cannot afford it, and we cannot stop the progression of the knowledge. So that was the case. And in 3 Idiots, Chetan Bhagat has come up with the 5-point someone, wherein although the consent was taken from the Chetan Bhagat, that is the economic rights, that can we make a movie out of it? He consented, right? But another thing is his moral rights were infringed, because if you will see the movie from the start until end, there was no kind of contribution given to him that it has been adapted from this particular book. And rather they have given the author's name, that is Anurag Mishra. That, so he offended even, but the director said only we have taken 3 to 4%. But as the previous speaker has told about, basically this depends on the discretion of the authority, right? They may decide it. So it was not 3 to 4% beyond that. So that was the case. And next is designs. So design is what? Which meets with the following criteria: novelty, satisfy the ornamental standards, must be non-obvious, must mean to a single claim. And as we have just discussed about prototype, not required as such, right? Even if you conceive in an idea of any furniture or anything like that, you please produce a CAD design, computer-aided design, that will do. That all are very important. So since we have already designed, a few questions were there on, so it could be 2D, it could be 3D, it could be on the surface of like, the shape, colors, anything has to, fulfill the novelty aspect, newness, right? But also not the functionality. Designs is of course makes, we have already gone through the same. A small example in a pharmaceutical, like how design plays, like tablet, the designs are there, it can be safeguarded, package inserts like copyrighted. That's again not required here. That shows how the incremental innovation works for patients also, gradual evolution. So always remember, even the small incremental innovation, don't think that won't serve the purpose. Rather, it may lead towards the disruptive innovation. So please come forward. Even if you have any idea, we are here to serve you only, right? So we'll discuss and make accordingly. So patents, small, already covered. These are basically a monopoly right for a limited period of time granted by the government in exchange of disclosure, right? And fulfill novelty, inventive step, non-obviousness, commercial utility, and should not fall under the section 3. There are a few patentable, non-patentable subject matter, right? So I'll take few seconds here. Reference to this particular domain in the fashion technology, although you can see only 2 coming from the institution, you may come up with a lot of, right? Like the way you're treating a fabric, the threads like that, or, even I'm giving an example, a company Novozyme, they come up with an example of an impressive success story wherein what they did is they had a stone wash jeans, that has come out from there only. And that was a patented technology. Why? Because in this technology, they use an enzyme called cellulase, and which removes some of the indigo dye from the denim, and that renders to the same. So this technology is patented, right? So likewise, even for the patent protection can be granted under technology, which can be like for the Croc shoes, how, that is so durable. Even the wrinkle-free garments, antibacterial, I think Marks and Spencer they sell the handkerchiefs with the antimicrobial activity. And recently, during the COVID time, we have come up with so many of such things like water repelling textiles or innovative ones, UV filtering textiles. You may think in that ways, right? So that will help you to come. And in this direction, you may take them. It could be a multi-institutional also. You may seek the help from few of them, like other departments. Then now the performance wear technologies can be patented, wherein the Nike has come up with a patent on a sneaker technology, or smart clothing and wearables, wherein the sensors monitoring the color change. We know that, some clothes are there which changes the color. And so wearables, embedded screens, so they all are patented. Unique fastening systems like zip fastening. If you are improving something, which is invention is nothing but problem solution approach, right? Question doesn't lead always to an answer. It leads to the quest. So it's a problem solution approach. Whenever you identify a background already existing normal day problem, come up with solution. If it comes with an improvement, that's a patentable, right? Sustainable fashion technology, fashion inventions, which aims at sustainability in fashion industry, accessories, handbags also, treating in such a way, or footwear innovations, the garment construction techniques. These all are patentable. Now, what is invention? Already been discussed here, right? So a good thing is there, in case the novelty is something which should not anticipate your, the present work. Any prior art which is not anticipating. Here, the patent office has taken a very good stand. Like 2024 rule, they have given a grace period. Means, even though your publication, work has been published, but 12 months will be given to you as a grace period, right? So that because why they have taken, because there are multiple scientists who basically, go unintended for the publications and not knowing it. So 12 months grace period still there. Inventive step should be technical advancement over the existing knowledge, or have economic significance, or should not be obvious to the person skilled in that art. And who is a skill in that art? The particular domain person only. Industrial application, invention or any creation of yours should not be, hypothetical. It should be plausible, right? Invention should be plausible and signifying the economic significance at the same time. So patent specification is what? It's more of like a research paper. The way you come up with the review literature, right? It's the prior art search. then you coming with an objective, then summary, and then the detailed discussion, experimental results. Only difference is claims. Claim is something, the techno-legal aspect, which differentiate the research paper, to the application. Now, I'll not take much here. Small 1 second here. As you have been already told, in India we have first to file the file patent. That means the moment you conceive an idea, 20% is there. You have not yet started with a experimental result, but to safeguard the date of priority, please file it as a provisional. That is 20% is okay for us. And then you will be given a year of time. By that time, we expect you to come up with a complete experimental results, give the data, what data, that wherein you are showing the technical advancement and solution to the problem. So that's the your complete specification. And what are important thing which is required, basically, if you are undertaking an invention, because whatever we have at the time of prosecution, we get to know, like at the time of invention, if you may come up with some validation data, some kind of advancement being shown through the experimental results, efficacy has been shown, or you can show how it is sustainable, how it is addressing to the SDG nodes, how it is low cost, working in an ambient temperature. These all small things really matters, to get your application through. Or in case of your herbal biotechnological research, it's always good to come up with the, your preclinical data, if possible, IC50 values, toxicological data, antimicrobial study. So that will ensure, and no one will stop your application getting through the grant phase. These are the basically are the responsibilities of IPR cell, right from the prior art search until the grant. We are here to handhold you, to guide you. So anytime we sit in the first floor E3 block incubator, you're most welcome. So not required documents. So again, since we have discussed about the criteria, usually in the prosecution, what we do is, at the time of drafting, we ensure what are the objections that we may face. So to ensure the same, we do the drafting in such a way that it goes through the examination successfully. So considering that, basically the objection we get is lack of novelty, anticipation, right? Obviousness, lack of inventive step. Now here I'll stop for a minute. Novelty. Whenever the concept note reaches to IPR cell, immediately we do the prior art search report, and we share you the prior art search report, sharing that these are the patent and non-patent literature which are impacting your novelty. Now, what is your further step is, make sure while undertaking the experiment, those who are very closely related, give the comparison data there only, right? So that, it will help you. It will help you, and we're in a position to give them a comparison. These are the closely related ones, and we have a good results over that, more efficacious. And also all enablements are there. Obviousness should not be, you have to clarify with the inventive step also. Insufficiency, because patents are granted either for the product or for the process, right? So product cannot be always a new product altogether. No, even incremental steps, making it, giving certain kind of, a problem solution approach entitles for it. Or process, not necessarily always a new process, but such a change in the protocol or the normal process, which is giving you the surprising results, that is qualifying for the patent. Now, next is sufficiency of disclosure. It is very important. When you are undertaking or addressing the objective of your invention, please make sure that your experiment validates the data, whatever objective you have proposed. Otherwise, sufficiency of disclosure comes up. And I'll not take much. Section 3B, anything which is contrary to the ethics, that is not patentable, or mere scientific principle cannot be. Section 3D, like if any compound is there, if we are claiming for a derivative of the same, we have to ensure that it is showing the efficiency or efficacy. Small example, it may pertain to the fashion technology students. Like for example, there are few raw materials, right? Now we have added potassium carbonate. First one is prior art. Second was it is invented process. Now 560 grams. Here the precursor is in invented process 160 grams. You have reduced the precursor substantially. Water input is 1500. Now it is 350 in your invented invention. Now effluent generation earlier in prior art was 1900. Now it is 450 granted for, right? So these are the things which we have to keep in mind for. Section 3, not required here, not required. This is one of the patent which has come up from the your domain, that is a method of dry dye on polyester fabric made by recycled plastic. It is a granted patent technology from Amity University, wherein they've used this technology, which is cost effective, sustainable, enabling the water-free dyeing. That is, air is used instead of water here, right? And which is textile 50 to 60% less of the carbon, sulfur dioxide. This is a granted technology. Now, another patent is microwave mediated impregnation of silver nanoparticles on fabrics for hygienic clothing. So such kind of variations, that's also a granted patent. Like it's a basically in case of mathematical method, software, what we have to do is please come up with an embedded technology or give the system approach, because software per se is copyrightable, not patentable. Hardware is patentable, but embedded technology qualifies for patent. 3P, though, I think it will not come here. Section 4, not now. The focus and thrust areas. I got a privilege to represent a country to the WIPO forum and WTO of WIPO. So wherein we were told numerous things on the, how it can be expedited grant also. So basically the WIPO agreement, they addresses the technologies which are addressing to SDG needs, the socially responsible innovations, which talks about the, resource optimization, such kind of technologies that they have requested the member countries to grant on priority. So we can focus on those areas, and public health urgency or digital health interventions, the unlocking innovations offered by the sunrise industry. So these are the ones which can be space tourism, telecommunication. Now, institution ecosystem. We have to understand the gaps in the research. Even if you send us the concept, we share you the prior art search report now. So identify what are the gap areas, what are the gray areas where I can, pitch in and offer the same. And also institution policy, your organization has a very well-defined robust IP policy, which says about all the arrangements like, ownership rights, benefit sharing arrangement, and ROI on your innovation. And also we have to come up with a collaborate, connect, and create. For, NEP mandate of research outreach, our Honorable Prime Minister, sir, has always given this particular incentive that come up with a collaborate, connect, and create. And if you want to come see the 2047, a country to be a developed nation, we have to move from incremental to disruptive innovation so that we can make the difference. Safeguarding IP and R&D policy, compliance. Compliance is important because always there is a timeline, and we keep reminding our innovators to please share on a particular timeline. So my request, please respect the timelines. What are the strategies? As already been informed, maintain an inventor's logbook. Important, very important. At the time of examination, we have to give the proof if it's not there in your specification. To have a very regular practice on that. And also mapping of technology is important. Do not assume again that invention is a minor improvement. No, it cannot over the prior. It can be patented. The minor can be valuable. At the same time, they are important. Also, what I think we assure, because our domain is very rich in the PhD scholars, thesis, the MTech or the graduate thesis students willing to come up for, our projects are being running here. So we do expect a good number of IP augmentation from here. So I think a few of time, like the consistent midterm evaluation were also being carried out. SRC, DRC may dig the same, may also, come up with the same. IPR, thank you. Thank you for your questions. If you have any questions, you may ask.
Do you use any specific website for buyer search or normal website? What I said to question based on this.
Okay.
Is there any likely chance that you like miss some overlook some information which may be very important?
Okay.
And later on we come to know we should have given to the inventor.
Okay. So to answer the same, my alignment or maybe parallel to review literature, not exactly the same, because review literature is more on you are searching on the Google or something like that. Prior art search dedicatedly we perform on a even any inventor can do it on a Google patents. There is a a particular website dedicated for the same Google patents. You may fairly cover up to like 60% of innovation. There are Indian Patent Office website, and every Friday the Patent Office comes up with a journal. So you may refer to that. Also EPO, European Patent Office is there, US Patent Office there, even the WIPO website patent scope is there, sir, which are free for access to an inventor. Fairly that will give you direction. So not necessarily the patent literature, but NPL also. Non-patent literature also, it plays an important role in prior art search. Yes.
Just because for someone who is on the creative side,
Right.
at times when your focus is more on that I have to get it published for the purpose of patent, the focus goes away from actually the creation. More focus is on like that I have to get it patent. Now, just during the process, can for this domain, especially the design domain or architecture domain or the arts domain, can the checklist be made where we or our students can be like referring that checklist
Right.
during the process of their work? That means the creativity is not disturbed, but somehow it can be tweaked in two stages with respect to that checklist. So finally, it can be like converted to some kind of way. So because there are so many do's and don'ts, and it's very difficult for someone to remember all those things while their entire energy is into something like creation. And creation, the biggest challenge with creation is that it needs continuity. Means I cannot think of that. Well, sir will agree that I started my painting for 2 hours, then I again restarted on next Friday for 2 hours. It needs continuity. So at times I feel that to promote this practice, and worldwide definitely some schools, university must be doing this. And we develop a tool for this department, and definitely we would like to
Right.
support in developing that.
Okay, please. Thank you, sir, for the question. Before I'll start to this, there is a National Intellectual Property Policy was introduced in our country in 2016, which lays emphasis in alignment to NEP that creative India, innovative India, right? So next to the same question, do's and don'ts with respect to our technology in the creative 24 and 25, we only ask the students participated there in an exhibition, according to you, what are the newness or originality? Because that answer can come from the person involved, right? And you yourself have answered, and 25 we identified then and there only. So of course, sir, we have come up with the do's and don'ts. So I will circulate it to you so that the one which we have discussed thoroughly will be taken care of. But the moment you please come across with, because we are the best judge, right, of our own work. So if you know that I am not copying to that, the inspiration could be, idea could be, no? Copyright is for expression, not for an idea. You may inspire, you may get an idea, but originality, newness is something there. Please reach to us. And I'll share and I'll leave my mail ID here. And I think from today itself, we'll see a sea change in the IP augmentation. And I keep on coming here and to meet you, but I'll not take much time of, and I'll respect your time also. Any?
Sir, I have an observation and a question, please. What we have observed that students, when they are getting into the idea creation at the initial stages, so we send them to the innovation and design department, and then for the IPR, I myself went to Dr. Sita for one of our students who was working in something. But then problem here is that once the student has all this ideation and has tried to create something as an idea, even before filing the patents and all, they have to develop a prototype and do the experimentation. And for this, they need some kind of monetary support. So, and if they don't get it from the university side, they're very much keen on taking it out from outside the university and give them the ownership rights of the idea, and then the other bodies from outside filing the patents. So that is very kind of an unfortunate situation when we hear this out that this idea is being developed here, but then the ownership rights are being given to some other organization that ways.
Like, for science departments, we all do. There's a purchase committee and in annual planning, we plan that this road is required for, so come to the science department specifically. Because मेरे यहाँ पे half ton reality PGP और outside, I don't know much about it. So they always say this is what our requirements are in terms of chemical reagents, equipment and everything. For UG and PG, it is not mainly for us, UG So similar kind of requirement, don't you send also from ASD or ASD? It's a.
Sorry, the challenge क्या है? The challenge is उसका जो plurality of material है, it can't be seen in advance. वो शुरू में नहीं देखा जा सकता. It is like that the product is evolving, now you need something else.
What I can extend here as a support would be in case of any product or any such kind of wherein you are claiming for, even the block diagram by which you are explaining the product per se will be sufficient for initial filing stage, right? And also the simulation study will also do. Because so don't get worried.
See what she's saying is actually, and definitely because she has mentioned in the feedback also that at the departmental level, there should be some kind of seed money that should be the hand of the department to carry out such activities. We keep doing through this our own budget, what we have, this 5,000 whatever. But I think we are missing on something. Let's say there is a batch of 40 students, and out of 40, we find that there are 1 or 2 students whose ideas can be converted into prototype. Now, the moment student goes outside with the vendors, get that prototype made, the idea means it has gone up. And by the time student completes it and convert it into something which can be the format of patent, that idea has gone. So it's more like, I do not know, that some kind of sequence at least for the
Money competition is the word, the moment they say word seed money. This implies for those 20 members, we recently revised the plans because even the staff of seed money. So that is mainly for the 20 members we have recently joined. As of now, there is no seed money policy. But we are coming up with the seed money for those. Like say new faculty member joins, their ideas, yeah, then we have to put some riders. It can't be for someone 50 years old or something. That's what they're saying. Or someone joins a fresh department in an institute, say your school, and wants to do some kind of a research or type or design in your, then that person should be given that policy is underway. It is being made. This is seed money foundation as of now. But what you are saying is different. What you are saying is something which you have foreseen, but the passage of time you realize that when you are working on a design, this something is required and you have to go outside the campus and your idea is like, okay, you're gonna be. So maybe I don't know what kind of need to be.
Sir,
is the benchmarking you always.
It's like sometimes the product design students, they bring the stuff from base material, right? At times, do it yourself kit जो आती है उसमें से कुछ लेते हैं. At times they try to purchase electronic items where they feel that the sensors need to be here. So it's so much of multidisciplinary field actually. So we cannot predict that what will be required and during
maybe some kind of a budget have to be paid.